Welcome everyone today to the Basel Institute on Governance's webinar on corruption sanctions. An unfortunate fact of the world is that justice is not universal. We'd like to think that all states around the world act in the interests of their people and protect them and make sure that if they're wronged, they're able to seek and achieve justice for themselves and their communities. But this is simply not the case. In many countries around the world, the state institutions, including those responsible for delivering justice, are controlled by the corrupt. In these countries, these institutions don't exist to protect and serve the people. Quite the opposite, actually. They exist and function to protect and profit the corrupt individuals that control them, to the expense and injury of everyone else. But what can be done here by the international community? The places I'm referencing here are sovereign countries. They don't fall under the jurisdictions of the countries that perhaps we live in. So aren't our governments simply powerless to influence any sort of change here? Maybe not. Today, we're going to talk about the concept of corruption sanctions, an option that governments can consider to target and disrupt those corrupt individuals that have long enjoyed impunity within their own legal systems. This afternoon, we'll be diving into these mechanisms, how they came about, why they exist, whether or not they've been effective, and importantly, whether or not they could be used more effectively in the future as well. Joining us today is, well, it's an absolutely stacked panel, I have to say. First of all, and guys, feel free to turn on your cameras now if you'd like. First of all, we have Anton Moiseienko, an associate professor of law at the Australian National University in Canberra, and the author of the Basel Institute's latest working paper entitled Corruption Sanctions: What Governments Need to Know, which we've published on our website in conjunction with this webinar. It's honestly, it's an excellent paper. I would highly encourage anyone who hasn't read it to read it if they haven't, and if they'd like to also learn a little bit more about the topic we're discussing today. Joining Anton, and yes, he has arrived, is someone that actually doesn't need an introduction, but I'm going to give him one anyway, is Sir William Browder. Thank you for joining us, Sir William. Sir William is the CEO of Untitled Chapter and the head of the Global Magnitsky Justice Campaign. He is someone who is deeply connected to the promotion of corruption sanctions and has played a pivotal role, or more accurately, the pivotal role, in their introduction and expansion across the globe. Next on our panel is Michael O'Kane, who is a senior partner at the UK law firm Peters & Peters and one of the UK's leading and arguably most experienced lawyers when it comes to international sanctions. To date, Michael has acted for over 150 clients designated under UK and EU sanctions regimes. Last, but of course not least, we are also joined today by Lyra Nightingale, Senior Legal Advisor and Head of the Financial Accountability Team at an NGO called Redress, which is an organisation that seeks justice for survivors of gross human rights violations around the world, including through the promotion of corruption sanctions. Thank you, everyone, for joining us today. We're very, very happy to have you. Before we crack on with the conversation, though, I just want to cover a couple of quick housekeeping points. First, the session today will be recorded and published online a little bit later. I think it's important to let everyone know that. And second, if any of the participants joining us today have any questions for our panel, please feel free to pose them. There is a Q&A function in Zoom, and we'd encourage you to use that to pose the questions, and we'll try to address them throughout the session where we can. So with that, let's get stuck into the discussion. And to lead us off, and to give us some necessary technical context, I'm going to turn to you first, Anton. Anton, could you please give us a quick overview of what we're actually talking about today? So what are anti-corruption or corruption sanctions?
Sure, Andrew. And I'd like to start by thanking the Basel Institute for publishing the paper, and you, Andrew, and the entire team for the excellent input that you have made, without which the paper would not have been possible. And also really grateful to Bill, Michael, and Lyra for joining us today to discuss the current state of play when it comes to corruption sanctions. So if one just asks that question as you did, what are corruption sanctions? The answer is very straightforward and perhaps misleadingly so, because it all seems to be incredibly simple. Corruption sanctions are financial and travel restrictions imposed by governments rather than courts on individuals and companies suspected of corruption. That's done in the absence of any finding of guilt in a criminal or a civil trial and based on flexible evidentiary standards. And so, although the mechanism, when you break it down like that, is, as I said, not rocket science at all, there are multiple issues that we're going to be discussing relating to the effects of these sanctions. What do they achieve? What can they achieve? The strategy behind their imposition, why are they used, and how can they be used more effectively, as you asked in your introduction, and also how can they be used in a fair manner. So the way that I like to explain corruption sanctions is that if you're a policymaker and the paper is primarily aimed for the benefit of policymakers, there are three important features that corruption sanctions have that other anti-corruption tools do not necessarily have. Number one is flexibility, and that's a function of those relatively relaxed evidentiary standards. Governments are freer to use corruption sanctions than they are to investigate and prosecute someone or take away their assets in asset confiscation proceedings. The second facet of corruption sanctions is their versatility. And that's because there are a raft of different objectives that countries might pursue in imposing corruption sanctions against particular targets. And then thirdly, related to all of that is the selectivity of corruption sanctions. It's not really a mass market product. You're not going to sanction thousands of people under your corruption sanctions program. Instead, you are necessarily going to be quite selective about whom you target, and therefore the question arises of, well, how do you decide on whom do you target? So that's all, I think, part of the essential context that hopefully sets up our discussion. And the only other bit that I would mention for everyone to be clear in relation to the actual restrictions that sanctions entail is, as I said, there are two categories of consequences that follow. There are financial sanctions and there are travel sanctions. So financial sanctions are the freezing of the assets of the targeted person in the sanctioning country, but also a prohibition on transacting with the sanctioned person. So if Australia sanctions someone and I'm in Australia, I'm not allowed to send money to the sanctioned person. And then on the travel front, depending on the position of the targeted person, they will either not be allowed to enter the sanctioning country, they'll be turned away at the border, or they might be deported if they're in the country already. And underpinning all of this is the further layer of reputational consequences attendant on being singled out as a corrupt individual. So that, Andrew, is where I would probably leave it for now in terms of the brief background as to what we're talking about.
Yeah, thanks, Anton. I know it's quite hard to condense the complexities of corruption sanctions into a 3-minute explanation, but I think you've done that quite well. So for those who haven't read Anton's paper yet, there's a whole section at the start of the paper which is talking about the history of corruption and human rights sanctions. And well, it's quite an important section because to really understand what the purpose of these tools are and what their use really is today, it's important to understand why these tools were created in the first place, right? So turning to you, Sir William, I hope you don't mind if I refer to you by your first name. You've devoted, much of the last decade and a half campaigning for these sanctions, and you're very much credited with triggering the first sort of major sanctions regimes in this context across the globe. Can you briefly give us the story of this, and can you let us know also just how has the journey since then worked out? Has it worked out as you expected?
Great that you're doing this seminar, and I always like working with Anton. I worked with him on the confiscation of the Russian central bank reserves, and I don't think I've ever come across an academic who can speak so clearly to the world, and so I'm honored to be alongside you on anything you do, Anton. So, and it particularly honors me because we're working on something which is my core mission, which is the Magnitsky Act and asset freezes and visa bans for human rights abuse and corruption. And it all comes about because of the dreadful, unbelievable, heartbreaking murder of my lawyer, Sergei Magnitsky, who uncovered a vast corruption scheme in Russia in 2008 and was then arrested by the same people who did the corruption scheme, tortured viciously in prison for 358 days, and killed at the age of 37 on November 16, 2009. And the Russian government completely covered up the murder, the torture, and the corruption that he uncovered. They were more interested in rewarding the people who committed the financial crime than they were in punishing anybody who killed Sergei Magnitsky. And for me, that was an unforgivable crime. It was something that has weighed on me from that day forward. And when I tried to get justice in Russia, of course, there was no possibility. And I said, if I can't get justice, and Andrew, as you mentioned in the introduction, at that time when I tried to get when I said to myself, well, how do we get justice in Russia? And everybody said, or the Russians said, there's no possibility of getting justice in Russia because there was no crime committed. That's when I said to myself, well, how do we get justice outside of Russia? And that's when I discovered that there were no legal mechanisms, that if a torture, murder, or a vast corruption scheme connected to that torture and murder had been committed in a country, then the only country you could really prosecute that was in the country of origin. And I found that to be an unacceptable situation. And in the case of Magnitsky, he was killed because he uncovered this vast corruption scheme, $230 million of taxes that we paid, and that the money wasn't kept in Russia afterwards, it was kept in the West. And so I said to myself, well, surely if the money is kept in the West and these people are traveling to the West, we may not have jurisdiction over them for torture and murder in Russia, but surely there must be something we can do in the West. And that's when I started traveling to different countries and lobbying for this idea of asset freezes and visa bans on the people who killed Sergei Magnitsky. And that was the genesis or the seed that led to the Magnitsky Act being passed in the United States, and then further on in Canada, the UK, the EU, Australia, Norway, Iceland, Kosovo, Montenegro, and other countries. And that was 35 countries that have the Magnitsky Act. And it really was revolutionary. And there's often times people saying, oh, this is not a very effective tool. Look, they're still murdering people and they're still doing corruption. How can you even say that the sanctions work? And I've had a lot of experience knowing that they do work based on the reaction of people who've been sanctioned. First of all, the Russians, when the Magnitsky Act was passed, went out of their minds, and the Putin regime made it the single largest foreign policy priority to repeal the Magnitsky Act. They then put Sergei Magnitsky and me on trial 3 years after they killed Sergei Magnitsky. The first ever trial against a dead man in the history of Russia. And they've been chasing me around the world with Interpol red notices and all sorts of other terrible things, trying to get me back to Russia so they could do the same thing that they did to Sergei to me. And so we know that we've hit the Achilles heel. I can remember after Jamal Khashoggi was killed and murdered, dismembered by the Saudis, and there was all talk about sanctions. There was this misimpression in Saudi Arabia and various other places that somehow I control who gets sanctioned or not. And so I started getting all these phone calls from all these random people in Saudi Arabia desperate to stay off the sanctions list. And what I learned from that is that it's not just the people who are sanctioned, but it creates a climate of fear among everybody in these countries that they could end up doing all these crimes, getting all this money, and then never being able to use the money. Let me just finish off by saying there's one huge challenge remaining in this project, and that is that we got the Magnitsky Act passed in 35 countries, and it works pretty well in all these countries in terms of how it's designed. with one huge glaring exception, which is the European Union. The European Union only has the Magnitsky Act as it applies to human rights abuse. And so people who commit corruption are free to travel to the European Union. And so there's many people who are sanctioned by the United States, Canada, UK, Australia for their role in the Magnitsky case and the corruption in the Magnitsky case that can freely travel to Europe. Why was that? Because throughout the years, every country of the European Union had to unanimously approve any sanctions laws or any sanctions designations. And so Hungary, Viktor Orban, always vetoed corruption as an offense under the Magnitsky Act. He's gone now. And so we now have I've got a new initiative, which is to get Europe to finally conform with everybody else so that corruption is included in the EU Magnitsky Act. And so when someone is sanctioned in one place, they can be sanctioned in every place. I'll leave it at that. There's a lot of important people to speak after me. Thank you.
Yeah, thank you, Sir William. Yeah, it's interesting. The political context in Hungary perhaps opens up a pretty big opportunity there. Also, he hasn't asked me to do this, but I also want to give a plug for Sir William's book, Red Notice. If you haven't read it, I'd really highly encourage you to read it as well. It's a fascinating and to be honest, quite confronting story that Sir William has to tell, and it really does give you a pretty good insight into why he does what he does and why these sanctions tools now exist across the globe. So with that, now I want to turn to you, Lyra. You represent an NGO which works at the intersection of corruption and human rights, and especially the rights. You work for the rights of victims that have suffered directly from corruption and human rights abuses. In your experience, what's the most valuable aim of these corruption sanctions tools? In other words, what could or should they achieve for victims that governments can't easily achieve through other means?
Thank you, and thanks so much for having me on this incredible panel. I really appreciate it. Some of you might be wondering why you've chosen to have a human rights lawyer on a panel regarding anti-corruption sanctions. But as we've heard, unfortunately, corruption often goes hand in hand with some of the most serious human rights abuses. So we've heard from Sir William the overlap between corruption and crimes such as torture, murder, arbitrary detention, and the appalling things that happened to Sergei Magnitsky, which is sadly all too common. So through a human rights lens, I come at corruption sanctions from a slightly different angle to perhaps others on the panel might. From a human rights perspective, we want to see sanctions being used to provide accountability, deter future violations, enable reparation, and avoid misusing them in a way that contravenes human rights. And in all of these objectives, as I think we'll probably hear later in the panel, we're at a slight inflection point. But there's one area of impact where we're not, and that's acknowledgement. So from our point of view, if a targeted sanction, such a corruption sanction, can convey recognition, acknowledgement, some sense of justice for victims, it will have had an impact. And I appreciate some of the audience might be skeptical of this impact of Magnitsky sanctions, especially in cases where a perpetrator hasn't got assets in the sanctioning jurisdiction. So I want to address briefly why it matters in general terms and why it matters specifically to the survivors that Redress works with. And this acknowledgement impact is often overlooked in favour of more concrete examples such as behaviour change, but I really don't think the importance should be understated. So at Redress, we work really closely with survivors of torture connected to corruption, and many of them have endured horrific abuses, so sexual violence, enforced disappearances, mock executions, prolonged periods of solitary confinement, really shocking violations linked to corruption that inflict unimaginable harm. And these survivors have got a right to remedy under international law, but as we heard from Sir William, in many of the cases, the perpetrators are beyond the reach of those traditional justice tools. So in many kleptocratic or corrupt regimes, there's no international court with jurisdiction, there's no prospect of domestic prosecution or recovery, it's essentially impossible. And while the sanctions alone aren't enough to provide a remedy, they're just one tool, and I'm sure we'll come on to that later. And they're a really important step, even more so when there's no other tools available. So even if the person designated might not feel those tangible consequences, and in many cases they will, the very act of them being subject to these sanctions, like calling out their misconduct, can be really powerful. So to give you an example, after the death of Mahsa Amini in September 2022, the UK and its partners imposed sanctions on over 150 individuals and entities involved in Iran's crackdown against protesters. And we spoke to some of those involved and interviewed them about the impact of these sanctions and whether actually it did have any meaningful impact for them. And we were told that the sanctions provided relief, that the world acknowledges the suffering and offered the glimmer of hope that someone out there is trying to hold officials accountable. We were told they demonstrate global solidarity in supporting the fight. And for the mother of a student that went missing following the outbreak of the protests, we heard that every time such a sanction is imposed, it feels like her child's disappearance isn't forgotten, and it's a sense of validation. So those were the human rights elements of the Magnitsky sanctions, but the same is true of the anti-corruption sanctions. So in 2024, the UK government designated Isabel dos Santos, as I'm sure you know, the daughter of Angola's former president, and she was accused of embezzling more than 350 million from state-owned enterprises. And Angolan civil society told us quite similar things, that the sanctions demonstrate that ordinary Angolans can no longer be allowed to languish in poverty, whilst privileged few appropriate public funds. We were told that they create hope, that they're a celebration of a concrete step to hold corrupt officials accountable and to protect the interests of Angola. And we've heard similar with regards to regimes such as Equatorial Guinea as well. So although sanctions aren't a cure-all, and there's different ways in which they can have impact, and they're just one tool in the fight against impunity for corruption, they really do have a really significant impact for survivors themselves.
Thanks, Lyra. So, Anton, considering what we've heard already from Bill, Sir William, about the situations that these sorts of tools address, and also from Lyra about the recognition they offer to victims, and sort of the symbolic impact as well that these sorts of tools can have. From your point of view, you've looked at these tools quite closely. Are there any more possible objectives that corruption sanctions can have, which are beyond those that have already been mentioned today? So, if a government doesn't already have some sort of corruption sanctions regime, why else might it also be beneficial for them to introduce them?
There are quite a few possible objectives. And the reason why it's so important is because there is this ever-growing and persistent anxiety about the effectiveness of any form of sanctions. And it's quite right for us to, every once in a while, to take a step back and ask, well, what are sanctions achieving? But there is a tendency in some quarters to be a bit dogmatic about, in particular, behavior change. And so Bill spoke a bit to that counterintuitive conclusion that you might arrive at if you look at the world through the lens of behavior change, and you ask the question of, okay, well, is there still corruption in country X after corruption sanctions have been imposed? And of course there is, because the reason why these people have been sanctioned is because they're the worst of the worst. They're very unlikely to stop. And then it would be perverse to draw the conclusion from that if corruption doesn't stop, then sanctions have failed. And so it's important to recognize that an important objective in and of itself can be disruption, so making life more difficult for people who seek to invest the proceeds of their crimes internationally and travel internationally. Deterrence, and again, we've heard already some anecdotal but very important experiences of people perking up and saying, well, my friend or someone I've read about on the news has been sanctioned. Am I going to be next? That's not great. The symbolic impact, as Lyra has highlighted, can be quite important. So I often describe that as condemnation, just making it clear that even if we can't necessarily put people in prison cells as a Western government, even just sending that message of condemnation can be quite important. A degree of accountability. You might describe that as a kind of punitive aspect of sanctions, but whichever term you use, punishment, accountability, again, setting that mark of this is inappropriate behavior and there will be consequences. And then finally, a couple of other objectives the states have been known to pursue in the past is actually to support the efforts of the territorial state where the perpetrator lives, for example, by facilitating asset recovery. That's what the EU's misappropriation sanctions sought to achieve in the aftermath of the Arab Spring, or simply signaling support for the territorial state's law enforcement action. So in cases of regime transition, there might often be doubt as to whether a particular prosecution of a former official is simply a political vendetta or something legitimate. And this is where sanctions from a broad array of countries can help them voice their support for what the new government is doing. So it's important to realize that there is this fairly broad array. And so I would argue that governments need to consider what are the tools that they have at their disposal to achieve those objectives. And then in some cases, it might well be that sanctions are the way to go, which means that if you don't have a corruption sanctions regime in place, at least you should seriously consider that in light of that versatility of objectives.
Yeah, thanks, Anton. They certainly, that's an important point to make. They also can very much complement maybe existing tools that are already there that have similar objectives, and give governments at least that extra sort of tool to use when perhaps those initial tools aren't achieving what they want to achieve. So it's quite clear, obviously, from your answer that corruption sanctions can have multiple aims. But I guess the question that leads on from that one is, are the current versions of these tools actually achieving these aims? So what's undermining the existing versions of corruption sanctions? And conversely, sort of what could be done to make them more credible and more legitimate and more effective? Turning to you, Michael, you've been involved in dozens and dozens of cases involving sanctioned persons, including cases where individuals were targeted under the EU misappropriation sanctions back during the Arab Spring, which have been mentioned a few times already today. Could you give us some insights or some stories about your experience dealing with these corruption sanctions mechanisms over the last sort of decade or so? And can you also provide us with some insights on what impact you feel that they actually had on the sanctioned individuals you're acting for? You know, what do you think these sanctions in particular are trying to achieve? And importantly, do you think they achieved it? Do you think they were effective?
Thank you very much. Thanks for the opportunity to talk about this today, because it's an extremely important and interesting subject. You're right, I've acted for a number of people who are subject to all sorts of sanctions, whether it's the thematic sanctions like corruption and human rights, but also sort of countrywide sanctions too. And it's difficult to draw generalizations. For some people, they are profoundly impactful, profoundly. And then for other people, they're not particularly impactful at all. And so I speak about this subject from the point of view of somebody who, drawing on that experience, would like to see them working better. So there are a few things that I think, first of all, historic mistakes that have been made, which shouldn't be made again, and I'll want to talk about that in a moment. But there's also things that could be done now in order to make the particular sanctions that we're talking about operate in a much more effective way, drawing on other examples from law enforcement and civil law situations. So I think the first overarching point I would make about these is that they are political tools. And when you are dealing with political tools, they are wielded primarily by politicians. And politicians will act for political purposes. And I think it's always important to be slightly careful when pure political purposes are involved and where the rule of law, due process considerations are put to the kind of the back of the queue. We saw this historically in a couple of situations which were quite important. Going back to the Arab Spring 2011, we had President Mubarak flee from Egypt. The Army Council came in to run the country, so it was a military junta. They then wanted to have restrictions imposed on various business people who were previously connected to President Mubarak and his family, etc. And they asked the EU to intervene. And the EU, acting out of, I'm sure, very well-intentioned, without doing any real due diligence, then put all these people onto sanctions lists. What was the objective of that? Well, obviously, partly it was signaling that we want to encourage the rule of law, we want to encourage democracy, we want to discourage corrupt actors acting in particular jurisdictions, and that's fair enough. But also an objective was that this would be a stepping stone to proper asset recovery. Well, what happened? Well, after 10 years, there was no serious asset recovery, and the people on those lists were all taken off the lists. The lesson from this wasn't particularly learned, because we had the same thing in 2014 when Yanukovych left Ukraine, fled from Ukraine, and the Ukrainian administration that took over at the time made a similar application to the European Union. Yanukovych and a load of people around Yanukovych were placed on sanctions lists. What's really interesting about that example is that it's very difficult to get off a sanctions list before the EU courts, but almost all of those people were delisted as a consequence of court challenges. And that is because no evidence was supplied by the Ukrainian authorities to back up the allegations of corruption. So I come back to the point that I'm making. If it's politically motivated, you have to be careful, and you have to make sure for this process to have real integrity, that when people are put on sanctions lists, it's well-reasoned and it's well-evidenced. Now, that's the historic. What I would say, particularly focusing on the United Kingdom and post-Brexit, is the UK's got its own autonomous sanctions regime. And it has worked pretty effectively from a rule of law due process perspective, because you get the reasoning for the person being put on the sanctions list supported by a sizable amount of evidence. And that evidence tends to emanate from credible sources. It's not witness statements, it's newspaper articles, credible NGO reports, that kind of thing. So that is a significant improvement. But where I know, Anton, you've said there's great flexibility in the corruption sanctions, I'm not disagreeing with you, but I think it could be an awfully lot more flexible. And what I mean by that is this. So at the moment, it's very easy, or relatively easy, for politicians to put people on sanctions lists. And it's very difficult for those people to get off sanctions lists. So there's an awful lot of stick and there's very little carrot. And I think the system would work better if it was possible to engage much more proactively with changed behavior. So what do I mean by that? Well, if you're a company and you are engaged, you find out yourself, you're found out to be engaged in corruption, you can go into the authorities, whether it's the US Department of Justice, the Serious Fraud Office, the PNF in France, and you can negotiate. You can say, we've discovered this problem, here's all the steps we've taken to rectify the problem, we're never going to do it again, we're paying reparations, you get a deferred prosecution agreement. That is changed behavior by the corporate in order to put itself in a better position. At the moment, very little is said by those who are devising the sanctions policy regimes about what changed behavior means in a corruption sanctions context. What does the person actually have to do in order to demonstrate that they are pursuing actions which are consistent with the objectives of the sanctions regime? So I think that from a policy perspective, it would be better to see more people being a lot more vocal about this, to try to encourage those who are seriously affected by the corruption sanctions to engage in conduct that's going to result in, one would hope, a relatively easy way for funds to be divulged and funds to be repatriated to the victim countries from where they have emanated. Because if you look at the most effective ways in which corruption has been dealt with over the last few years, you take the 1MDB case, for example. That was a very successful example, going all the way from people in Goldman Sachs to the government in Malaysia to Middle Eastern countries. And it was primarily as a result of hard work done by the US Department of Justice producing a very detailed civil forfeiture filing and going after everyone's assets all over the world. And lots of money has been repatriated to Malaysia, where the sovereign wealth fund suffered significant losses. And the other way of doing this, I would say, as a way of bolstering the corruption sanctions, is look at, once people have been identified, are there any sort of civil opportunities under civil law to sort of go after those individuals? Because one of the problems, I know Bill says quite rightly, the sanctions are adopted by 35 separate countries, but they're not necessarily countries that are working together, and the sanctions are restricted by the jurisdictions of those countries. We live now in a much more fractured world. There's lots of talk these days about the world order, sort of collapsing. That means there's less international cooperation. So what you can do in situations like that, you can see the civil courts can step in. If you are a sub-Saharan African country and you have suffered significant corruption by some bad actors, if you produce relatively limited amount of witness evidence and money flows showing funds going to Jersey, Cayman, the BVI, wherever it might be, you will get a worldwide freezing order from a commercial court a commercial judge in the High Court in London, in half a day. And that will have a very, very, very significant impact, because it can then be imported into the various jurisdictions where the assets are, with a view to not only freezing, seizing, and repatriating those assets. So I think, corruption sanctions have their place, very good for signaling, but in terms of taking the next steps, I think there's quite a lot more that can be done.
Yeah, thanks, Michael. Very interesting. So what I got from you was, a bit earlier in your response, was if there's more clarity, almost there's more credibility. So the more reasons and more evidence that are presented for putting people onto these sanctions lists, the more legitimate maybe they seem, and the more opportunity it gives to them to find reasoned ways to get off those lists as well. Interesting. So turning back to you, Sir William, and also Lyra, I just wanted to ask you, do you agree with the views that Michael has expressed? Do you think maybe corruption sanctions have been a little bit more effective than what he has suggested? Do you agree with the ways that he thinks they could be improved, or do you have other ideas perhaps on how these tools could be improved going forward?
So, if you don't mind, I'll go first. And Michael has said that his first statement was it's easy for politicians to put people on sanctions lists, and it's really hard to get off of them. From my experience as a campaigner, and I'm sure Lyra will say the same thing, is that it's almost impossible to get people put on the sanctions list. You may have these occasional moments, maybe the Arab Spring, maybe the Maidan, but for the most part, when somebody does something terrible, I would say that. So what would happen is redress in the UK, or Human Rights First in the US, or Open Society in Europe will put together a sanctions package, a detailed sanctions package with the most evidence, piles and piles of evidence. They'll submit it, and nothing will ever happen. And I've seen this so many. I would say that of all the people who want human rights or corruption sanctions imposed on people who've committed terrible crimes, I would say that maybe 1 or 2% of the applications ever get any attention. And in fact, one of the big political agendas that I have right now is to try to make governments more accountable to parliaments, and parliaments are all screaming bloody murder about this, saying that, what about this, what about that, what about this terrible atrocity, what about that, and the governments just ghost them. The second thing I would say is that the reason that you have these extraterritorial sanctions is because of a failure in the system of law enforcement and prosecution in the home country. So in the case of Sergei Magnitsky, the government said he wasn't murdered, he died of natural causes. The government said he didn't uncover a financial crime. He was actually the financial criminal. All the people who got rich off the financial crime, they got rich legitimately, even though they were paid $500 a month for their official salaries. And there was no ability to prosecute them because the government took that decision. And so therefore, we created a mechanism to create consequences for them in a place where there was some accountability. And so, how does a person get off that sanctions list? I would imagine, and I think that the way we thought about it is if the country where the crime was committed actually enforces laws that are on their books and prosecutes people for torture, murder, and corruption, then, and they've served a sentence for those tortures, murders, and corruptions, then they should be taken off that list. And then the final thing on, and I know this on this whole civil action. So Sergei Magnitsky and I and all of our colleagues were victimized, mostly Sergei, but everybody else. We have many lawyers who had to flee the country that have never been able to go back to Russia. There's been all sorts of nasty stuff happening. And one of the things we said was we want the money that they stole frozen and confiscated for these people. And it's not like I'm a huge corporation. I'm just an individual. I've got a bit of resources. And so we've spent 16 years going around the world working with law enforcement agencies, trying to get them to freeze and then confiscate the assets. And I would say that it's almost a futile exercise. Some of them have frozen the assets. Some of the money continues to be frozen. Some of the money has been given back to them. Some of the money has been confiscated. But it's been, I mean, the difference between the theory and the reality is so stark that I don't think that really exists as a possibility. If it doesn't exist as a possibility for a sophisticated financial investigator like me, it doesn't exist as a possibility for a little African country where nobody knows what they're doing or how to do it or how to trace money or anything. And so, I'm actually glad Michael's here because normally everyone agrees on everything about in these cases. Michael and I are friends, but I have to disagree with most of the stuff that we just talked about.
Thanks, Sir William. Lyra, is there anything you wanted to add to that as well?
Thank you so much. I'm slightly in between the two, I think, with Michael and Sir William. So William's saying it's almost impossible to get someone on the list. Michael's saying it's way too easy to get on the list. And I think it completely depends what list you're talking about. So these targeted sanctions, they're really, really underused, I would say. I'm with Sir William on that one. They're very different to those countrywide thematic regimes where, so in the UK, for example, we've seen, I think now over 3,000 designations in response to Russia's full-scale invasion in 2022. In relation to the anti-corruption sanctions in the UK, in a much longer period, they came in 2020, we've seen, I think it's in the 60s now. And I would agree that it's almost impossible to get someone on the list. So they're really, really underused. Now, clearly, the Russia sanctions benefit from high political urgency, and the invasion of Ukraine is seen as a major foreign policy and security issue. Magnitsky sanctions seem to lack the same political momentum. Corruption, whilst it's really important to the British government, apparently, in a lot of their posturing at the moment, it's got less immediate political prioritisation, and that's what's making it much, much harder, I think, to get people on the list. But I do think Michael's absolutely right in the fact that they're really over-politicised, and we're seeing the impact that has at the moment. So in the field of international justice, I think sanctions are really facing a make it or break it point. They're so powerful, but they're also reaching this, I would say, a new degree of politicization that we've just not seen before. And without those proper protections in place, they can be abused, which is going to undermine their credibility. And we're seeing, I would say, the human rights law that we're seeing that at the moment in international justice. So the US sanctions against the ICC, for example, they're going further and further. And a rise in these types of designations, whether they're related to corruption or not, can undermine the entire sanctions regime. I would also say an area that could really be improved is they're quite limited in scope in the UK, at least, and they're not that wide reaching. So in the UK, what we haven't really seen yet when we're talking about this kind of behaviour change or deterrent effect is we haven't really seen them being used to target the enablers of this kind of corruption. So the UK's latest anti-corruption strategy, it makes a commitment to expand the use of sanctions to target professional enabler networks. But I don't know how much appetite there is to really go after the domestic enablers of corruption in the UK. So the lawyers, the accountants, the financiers, facilitating these cross-border illicit financial flows. So an example, we've seen really impressive coordinated sweeping sanctions against the Prince Group in Chenzi But I wonder if we're ever going to see sanctions against the kind of the onshore or domestic enablers of those illicit financial flows who've channeling that money into London. And I'd have to really agree with Michael actually on the point around the lack of transparency and in government decision making, and really raise questions about clarity, fairness, how someone gets undesignated. I completely agree with that. You know, if we don't know what they need to do, then there's less of an incentive for change. And it does make it very hard for civil society as well to know what the government is meaning to do. And they're not particularly responsive, as William answered, and how we get someone on the list, what they need, because it does go into this black box. And there seems to be a kind of a lack of strategic priority there. And again, finally, I would say, pointing to the politicisation point, a real double standards in who the government's willing to sanction. And again, going back to that foreign policy tool, therefore needing that judicial kind of holding to make it compliant with rule of law.
Yeah, thanks, Lyra. Yeah, I agree. I think the politicization element of these tools is impossible to ignore, and it's something I wouldn't mind exploring just a little bit more as well. Now, Michael, I saw you scribbling furiously as Sir William was talking there, so perhaps let's turn to you quickly as well, and just in case you have any responses to what Sir William or Lyra has said, and beyond that. I also wanted to get your opinion, or at least expand on what you've already said before. Is, given the political concerns and the politicization issues related to these tools, how do you think that could further be negated in a way that would grant these tools more legitimacy going forward? Is there a way that the processes surrounding these tools could be improved, or maybe the deployment of these tools could be improved in a way as well that would just make them seem more credible, more palatable to everyone?
Yeah, I was scribbling a little bit because what I wanted to say in response to Bill is that when I say it's easy to put people on lists and hard to get them off, it's easy for politicians to put people on lists. There are roughly 5,500 persons on the UK sanctions lists at the moment. There have been about 15 delistings. So politicians, and the structure of the UK system, which is very similar to the EU system, is that the evidential thresholds are very low. Most of the stuff that goes into the evidence packs is all publicly available information, which is put together from Google searches, etc. And then the person gets put on the list. You're right, though. I agree with you. If you're a third party and you're trying to persuade the government to put someone on a list, that is difficult. And that is a really interesting question as to why that's difficult. And I am only speculating, but I suspect one of the reasons is that the government wants to be seen to be acting independently. The government wants to be seen to be reaching these decisions without any influence from any outside sources, because if a person challenges their listing, they get into court, there's all sorts of disclosure obligations that arise on the government, and they're going to have to make all sorts of disclosures about whatever representations have been made, whatever meetings may have been held, etc. And it may potentially expose them to the suggestion that they have not acted independently using their, what's described in the Supreme Court case of Schwidler, their sort of institutional expertise. So I suspect that might be going on, and it may be that there are more conversations to be had with the government around that to see if that is a legitimate concern and whether anything can be done about it. I also agree that it is difficult when there is no ability for the law enforcement in a particular jurisdiction to take the steps that are being taken. But that doesn't exclude the possibility of taking the civil action that I've talked about. It also doesn't exclude the possibility, and I've seen this in some cases, where there is a lack of capacity within say a developing nation to be able to deal effectively with a particular corruption case. And in those circumstances, putting people on corruption list is fine, but it would also be particularly effective if perhaps the countries that have the capacity could do some capacity building in the other countries to ensure that they're much more effective about tracking and tracing and seizing and bringing criminal and civil cases. So I definitely think that that is something that can be looked at in terms of international development, budgeting, and specific projects. And I think an overall point that we have to mention on this on this call, on this webinar today, is the changing status of sanctions as a consequence of what is going on in Washington. There is, in my view, no doubt that insofar as the application of global Magnitsky sanctions is concerned, for example, the current administration is doing much less than former administrations have done. Even the first Trump administration sanctioned, I think it was 101 targets under global Magnitsky in the first year. This year, insofar in the Trump administration, they have delisted more people than they've actually put on the Magnitsky sanctions list. And that is I think that is a very potentially, quite a troubling development, particularly coming back to what I was saying earlier about the degree to which these regimes are sometimes very influenced by political motivation. And we've also, we've seen this in the way in which the International Criminal Court has been targeted by sanctions. I think it's a matter of some irony that the very first United Nations ombudsperson, created under the Al-Qaeda and Taliban sanctions after 9/11, was a very experienced Canadian lawyer, and she was very successful in that role. Subsequently moved on and ended up at the International Criminal Court, and she was sanctioned last August by the United States in relation to some actions that were taken in respect of investigative orders in Afghanistan. So my point about that is that we want to maintain the integrity and the respect for sanctions. And if certain actions are taken in relation to some aspects of it, I think it bleeds through to some of the others. And one wants to really try to avoid the criticism that will naturally come, that these are all essentially, politically motivated and not sufficiently backed up by, the rule of law and evidential considerations that I've mentioned.
Many thanks, Michael. Given that we are running out of time, I wanted to give Anton also an opportunity to re-enter the conversation here as well. And Anton, if you've got any responses to any of the comments that have come before you, please feel free to give them. Also, just to get your feeling, you've looked at these tools really quite closely now for a decade or so. If you had to name one or two things on how they could just be improved in some way going forward that would make them more effective, perhaps to negate this politicization issue or another issue, what would you suggest?
Yeah, thanks, Andrew. And as you said, I started looking at sanctions, corruption sanctions specifically, right before the Global Magnitsky Act was adopted. So I've sort of been following the evolution of that in real time. And one thing that always struck me is the paradox that we've kind of had traces of today, which is that if you look at the legislation and court cases, it would seem that it's incredibly easy for governments to sanction people, and it's difficult to get off because governments have so much discretion. So the way that I always put the point across is, if a government wants to sanction you, they will. Even in the EU, despite the protections afforded by the Court of Justice, the EU can simply relist you with a slightly different justification, and they'll have litigate again and again and again. So governments do have an extraordinary amount of power and discretion. But on the other hand, whenever you talk to governments, they always speak as though they don't have that discretion, and they highlight just how difficult it is to assemble the evidence. And civil society have the experience that we've been discussing. And so what I think has been happening there is something that in a reasonable amount is actually incredibly healthy, which is self-restraint and being quite cautious with the way that you use sanctions. Because the moment that governments start looking as though they're quite trigger happy and profligate and undisciplined in their use of sanctions, then the entire confidence in the system will, I think, collapse. And I fear that we're kind of flirting with that state of affairs in the US in particular. So I wholly endorse what Michael and Lyra were saying about how essential, proper, credible, restrained use of sanctions is to the credibility of the whole project. And we also need to bear in mind that there are many states that are incredibly keen to delegitimize sanctions as a whole. And so whenever there's an outrageous example of excessive use of sanctions, like sanctions against ICC judges, there will be people in organization who will be incredibly adept at using that in their advocacy. So I think that's an important area to follow and to bear in mind. And the only other point that I would make is I agree entirely with Michael and Lyra and Bill about the importance of broader strategy and a post-imposition strategy. So yes, sanctions are there. Is there a next step? And if that's asset recovery, well, what is the theory of how we get to asset recovery? If it is improving the conditions in the country concerned and kind of sending a strong signal of, don't engage in corruption, what else could be done beyond just designating one or two people from that country? So I don't think it's necessarily about laying a path for people to be delisted after they've engaged in heinous crimes. That might or might not be appropriate depending on the situation, but a broader strategy, I think, needs to be there.
Thanks, Anton. So, as always with these events, we're running out of time, which is a real shame, because I think the conversation has been very interesting. Before we do wrap up, though, I'm going to try to address a couple of questions that have come up in the Q&A. I did note, however, that a couple of these questions have been addressed in your responses already. So, Michael, I think you inadvertently answered a question there from Natalia relating to the politicization of the issue in the US. But perhaps I'm going to pick this one out from Robert Wild, who, if it's the same Robert Wild, I think has written his own book on sanctions in Australia, actually. So Robert asks, I would be interested in the panel's views about the harmony or lack of harmony between various sanctions regimes. For example, various regimes adopt what is termed a 50% rule, so those sanctions can reorganize their affairs, reduce shareholdings and control and influence, and almost carry on business. Yet under Australian sanctions, there's no such rule, and a far more binary approach that severely circumscribes any dealings with a designated person. What is the preferred approach? I'll leave that open to everyone. Perhaps Anton, maybe given the context, you can jump in there as well. So how do we deal with the lack of harmony between sanctioned regimes?
Well, I'm sure Michael would have views, but I would only say that I've got a 3-year Australian Research Council funded project on that issue specifically, so I can't prejudge what we'll find. But if this is the same Robert Wild, then he's been invited to the advisory board of that project as well. So I hope that he'll keep learning as we go about what the different approaches might be.
I would only say, but I think it'd be very interesting to hear from Bill on this, because obviously he's got cutting edge experience on going around the world and trying to persuade jurisdictions to create the sanctions mechanism for dealing with corruption and human rights abuses. I think more broadly speaking, there has been, obviously, the main sanctions event of the last 5 years has been Russia's invasion of Ukraine. And in respect of that, broadly speaking, the G7 have moved relatively in step with one another. That has somewhat changed since the new administration came into the White House, where the political priority was on seeking some sort of negotiated settlement. So there haven't been the same level of sanctions being imposed by the US as have been imposed by the United Kingdom and the European Union, particularly targeting the energy sector, shadow fleet, etc. I would also just finally make a sort of cri de coeur, which I think there is an opportunity here for the United Kingdom as the US sort of steps back and the EU is much more bureaucratic. There is an opportunity for the United Kingdom to really become a sort of global leader on sanctions policy now in relation to what we are talking about, specifically in relation to the sort of corruption, human rights abuses, but also more broadly by adopting a more flexible approach to delisting.
I'll just chime in here. So in a perfect world, all the major rule of law countries would have the same version of the Magnitsky Act with the same terms, and then sanction all the same bad actors together, because then the bad actors would effectively be barred from doing business or traveling. But we don't live in a perfect world, and so, as this has been my main sort of life project, the objective has always been, let's just get something on the books and then we can improve it. And so, for example, Canada passed the Canadian Magnitsky Act in 2017, and there's now a new Magnitsky Act to sort of go and fix all sorts of different holes that we've learned about from 10 years of experience with the Canadian Magnitsky Act. And then hopefully from fixing those holes, we can go to Australia and do an amendment to the Australian Magnitsky Act. And hopefully by the time we're done with that, the US administration will have changed, and you'll have a new US government that will be back in, the world of international cooperation and international law enforcement and so on and so forth. It's a very iterative process, very inexact. There's this expression, you don't want to see how the sausage is made because it doesn't look very good. And that's certainly how the whole process of advocating and for different Magnitsky Acts and getting things fixed and harmonized. And I just want to say one last thing about the deterioration of credibility for this, and that the US last summer decided to sanction the Brazilian judge who was prosecuting Bolsonaro because because Donald Trump was friends with Bolsonaro, and there are many people in Brazil that don't like that judge, and there's many people in Brazil that don't like Bolsonaro. But the Magnitsky Act should never be used is for major human rights abuse cases, torture, murder, that kind of stuff. It's for major corruption cases, and a judge who someone doesn't like should absolutely not be on it. And so, and a lot of people ask me afterwards, do you think that ruins the credibility of the Magnitsky Act? And the answer is not. One instance doesn't, but if that became the norm, then it certainly would. And so I do hope that some sanity prevails in the United States over these types of policies.
Thanks, Sir William. I think it is important to recognize that this is definitely very much a work in progress as an issue. It is comparatively a very new issue in law as well. So undoubtedly there will be some development over the next few years, which I personally will be following with a lot of interest. Given the time though today, I think we might have to bring the session to a close. Before I do though, I'd like to do a couple of things. First of all, answer one question that I saw pop up in the chat, which is there any material, research, evidence, or books that one can read to understand more about this? Of course there is. First of all, I'd recommend that you read Anton's paper, which is available on our website. It goes into this issue very deeply. It's an excellent read, very insightful, and very well written. So I would encourage you to use that as your first point of call. Beyond that, once again, Sir William Browder has written a couple of books that really do give you the context on why these tools are so important. So I'd highly encourage anyone who hasn't read those to go and have a look at those too. Lyra works for an NGO called Redress, and there is quite a bit of material on their website as well that I would encourage those participants interested in reading to go and read. I'm sure you will learn quite a lot from there in the work that they do. And Michael, you are the author of a website, Global Sanctions, no? globalsanctions.com. Yeah. So if you'd like to read a little bit more about Michael's insights, I would encourage you to visit that website as well. So with that, once again, I'd like to thank you, all the panel members, for joining today. Once again, it's been a very interesting conversation. It's a privilege for me to have been a part of it. For everyone that listened in and watched, I hope that you found the discussions equally insightful. And if you'd like to learn more about the topic, of course, please go to the sources that I've just mentioned. Thanks again, everyone, and have a good day.